Good morning, good morning, good morning. It is Friday. It is June 28th. I am coming to you live from VidCon. I have a panel in a little bit, which is, of course, what it is today because I have a panel in a little bit at VidCon. This jury is getting squirrely. We're going to be talking about the Karen Reed case briefly. Today's going to be a much quicker live stream than normal, but I know you're going to have a lot of questions about what just happened in court. It is day 4 of deliberations. It's Friday. We've got a holiday week coming up, and we have had much longer deliberations than I anticipated in this case. There are a few reasons I think why that is, but we are going to go to court. We are going to watch the 10 minutes of what happened in court this morning with the jury question. And then I am going to answer a few questions and then we're going to roll. But at this point, it looks like this jury is going to be hung. I think that we are probably not going to see a resolution. Could they hang on all the charges or just one or two? Yes and yes. But I think that they are hopelessly split. So we are going to go there. But first, look, can I show you the gift I got from YouTube? We got our little creator collective, we got our little button, we got a little I am having a good but anxious time at VidCon because I am waiting to see what this jury is going to do. I thought that they would be resolved. And I think at the end of the day, today, we are going to hear a lot more about this, because I think they'll probably go back and deliberate until about 3:30 Eastern or 3 Eastern and send out another note and be like, we are done. We are done. And I think the jury probably is done. And when they are hopelessly split, I've had a couple of the trials I've been in hang, and we'll talk about that. Let's see what happens in court. We're going to roll the intro real quick. Let me know where you're coming in from. I'm coming in from Anaheim. Yes, I've got a cold brew. Yes, we just got back from Starbucks as this was going down, because I was like, okay, the jury's been quiet. I have a panel today, so we're gonna get some stuff. And so the team's like, you need to be getting ready for your panel. I'm like, it's gonna be fine. We need to talk to the law nerds. So that's what's coming first. If I don't have eyeliner on, no one's going to tell I'm on stage. It's totally fine. I needed to be here with the law nerds. We needed to do this first. This comes first. So let's roll the intro. Let me know where you're coming in from, what you're drinking, and we're going to go to court to talk a bit about what this jury's doing.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
All right, law nerds, I know that this is stressful. I know that it can be confusing. I know that there's a lot of questions about this, which is why I'm like, no, we're going live. We'll figure out the rest of it. We're absolutely going live. And for those of you asking, I saw our app notifications come through quite a bit ago. So if you did not see that, you can always try making sure that your notifications are all on, because my app notification came through. So I hope that yours did as well. So with all of that, we are going to roll. And Miguelina, if we want to send another notification, just to double check, because I know the law nerds will want to know, we can also go ahead and do that now. So thank you guys, and let us get rolling, shall we? All right, because the app crew is going to be like, where we at? So thanks, Magdalena, for sending another one. Sometimes we got to just double up. Some of you guys are saying I didn't get any messages. All right, we will send again and make sure that everybody knows. And then Warren and Chris, if you guys can just make sure that you got your notifications, and we'll figure it out. So let us go to court, and then we're going to see what happened. A lot of you are saying no app notifications. Okay, we're on it, and we're going to roll to court and get into what we're getting into, and then we will talk, because this jury is going to they're going to keep us guessing, aren't they? Let us go to court, shall we? Let me make sure our volume is good. Emily, how about we check our volume first? It's like you haven't streamed in 3 days and you don't know what you're doing. I know my voice sounds like I've been streaming nonstop, doesn't it? All right, let's roll. Oh, I forgot.
Bring the jury.
Thank you. See the closed session.
We're back on the record on 22-117 Commonwealth versus Karen Reed.
Okay. All right. So, counsel, you're aware of our note from the jury. Dear Judge Cannoni, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. Signed by
Exhaustive review of the evidence. That gives you an indication that they feel like they've gone over everything and that there is nothing that can be provided to them or told to them that is going to help them resolve it. Exhausted review of the evidence, and they cannot reach a verdict.
by the foreperson. So I want to hear from counsel your view on whether there has been due and thorough deliberation. So let's start with the comment.
So the judge is going to allow the attorneys to answer or to argue. The judge, Wi-Fi, the judge can send them back multiple times to see if it helps, but that doesn't always help. But they are never going to say, yes, you're hopelessly deadlocked the first time. They are absolutely going to continue to send the jury back at least once. So, if not more. So let's hear what
My
Lally
answer would
has
be
to
no,
say.
Your Honor. This simply hasn't been sufficient time yet.
And what does the defense say?
We believe that there has been sufficient.
All right, so I'll hear from both of you in more detail. Mr. Lally, I will hear you.
Your Honor, the jury received this case just earlier this week. They've had slightly shortened days, and I'm not in any way, shape, or form suggesting that they haven't conducted their due diligence in regard to their deliberative process, but I would submit that it is far, far, far too early in their deliberative process to even consider giving them any kind of Tui Rodriguez instruction or anything close to that. Furthermore, what the note doesn't really indicate affirmatively that they can't come to a conclusion. It just says that they haven't come to a conclusion through their deliberative process at this time. They're not even asking for one, is what I would say.
All right, thank you. Ms. Giannetti, I'll hear you.
Your Honor, I would disagree with Mr. Lally's characterization of the note. The word exhaustive is the word I think that's operative here. They're communicating to the court that they exhausted all manner of compromise, all manner of persuasion, and they're at an impasse.
Right.
You know, this is a case where the jury has the legal instructions. They've only really asked one question, which was to try to get a report that they were not allowed to get. And I think the message has been received that the evidence is closed. They won't get anything more.
Yes, that's clear.
They've been working essentially nonstop over the last 3-4 days. We're approaching a weekend.
That doesn't
they
matter.
didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is
they're going to turn right back around and go back into the jury room is where they're going to go.
And go from there.
Okay. All right, so you all know that it is
Chad, I'm going to get to questions.
within my discretion, I decide. So a case that has been, it's a long case. This is our 4th day of deliberations, but Tuesday was a short afternoon, maybe 2.5 hours.
3.
Wednesday, they left early because of an appointment. Yesterday was also shortened a little bit. And this note arrived with less than 3 hours of deliberations today. So the length of the trial, the length of the deliberations. I know the case we heard from 74 witnesses. There are 657 exhibits, very complex issues in this case. I'm not prepared to find that there have been due and thorough deliberations at this point. So I'm going to send them back out. We'll bring them in and we'll do that now.
All right. They are going to bring the jury back in and tell them basically, get back in there and continue deliberating. For those of you asking, why would the defense want to let the jury hang? Because for them, a hung is better than her getting convicted on any of the counts. So the defense is going to say, hey, let's just call it a hung jury now. That's a win for them. Could Karen Read be retried? Yes. But if she's convicted, then they've got a long road to go. And at this point, if she was going to be acquitted, the defense, I'm sure, is assuming the jury would have done that by now and would have done that quickly. So this jury has indicated to the court that they are unable to reach a verdict at this point after, quote, exhaustive deliberation. The jury is allowed to be sent back multiple times. And if she does hang, or if the court does hang and the trial does hang, then the prosecution can choose to retry it or not. But at that point, we'll start seeing the court possibly asking for the split of the jury. They have to be unanimous. If it is one person that is a holdout, then you will see that the jury instructions are not clear on the second charge with all the lesser includeds, and neither lawyer went through those lesser includeds to inform the jury how to come to a decision there. But the real question here has always been, did Karen Read hit John O'Keefe with her car? And if the jury fundamentally can't agree on that, and we saw them on day 2 asking for the cert report, and they were told they can't get it. If the jury fundamentally can't agree, if some person's like, no, this is what she said, this is the taillight at the scene, you're not going to convince me that she didn't hit him with a car, then they can be hopelessly deadlocked. Because if you believe that the evidence does not prove that Karen Read hit him with a car, and somebody told you no, you have to believe that, what would you do? You would just be like, no. So I can see where if somebody's like, she absolutely hit him with the car, and somebody else is like, she absolutely did not, how they would just be at odds. And when you see somebody who is facing convictions for murder, jurors can really stand their ground on that, saying, this is too important for me to change my mind. Let's see what the judge says to the jury, shall we? The jury is now here. And so the jury is back in the courtroom, and the judge is going to instruct them to go back and deliberate.
As I'm in receipt of your note, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict signed by your foreperson.
They said they were diligent.
We all know how hard you've been working. Lunch will be arriving shortly. When it comes, I'd ask you to clear your heads, have lunch, and begin your deliberations again. Or continue your deliberations. All right? So I'm sending you back out.
All rise for the court, please. Follow me, please.
We will see if this jury is able to reach a compromise today, or if they are not able to reach a compromise today. So for those of you asking, can you still pull a jury if they're hung? Yes, you can. You can still pull them. But when they come back in, if they do this
All
again.
right, so the note has been marked for identification, and we'll see you all either at 3:30 or when you get a phone call.
All right.
If they come back again and say they are
Triple
deadlocked, they will be charged to go back probably again. So will we see them, being done today? I don't know. The court may choose to send them back to think about it over the weekend and bring them back on Monday. So the court has a lot of options here. How often do hangs resolve? That percentage goes down the more serious the charge is, because the jury instruction here is to a moral certainty. You need to believe the defendant is guilty beyond a reasonable doubt and to a moral certainty. And if you feel that you cannot say to a moral certainty that Karen Reed hit John O'Keefe with the car or vice versa, how do you come back with a verdict? Like, how do you come back with a verdict on that? So the jury seems to be deadlocked. It is very likely that they will remain so. And for those of you asking about Allen charges or Toohey charges, the judge isn't there yet. But yes, the judge will give them a stronger charge of going back to deliberate if they come back again and saying we've deliberated more. And we'll probably send them out over the weekend to deliberate more, which will just frustrate them. But I can see the judge giving them the weekend and saying, but think to yourself, if you are sitting in a group of 12 people and you feel whichever way you do about the case strongly, for those of you that don't have a strong opinion, don't worry about the exercise, but you have a strong opinion about this case at this point. You've heard all the evidence and you strongly believe one way or the other. Can you imagine somebody telling you, no, we're not doing that? How do you change that position? Especially if jurors feel she's guilty, then they are going to be like, no, the victim deserves justice. You're not going to change my mind. And if the jurors believe that she is not guilty or the state hasn't proved it, they're going to say, no, I am not convicting someone of murder or a lesser included charge of murder when I don't know if she hit him with her car. Like, you just can't change my mind. Like, that's just it. So if that is where they are deadlocked, I don't know how you move off of that deadlock. I'm going to answer just a few questions, and then I do have to go and get ready for my panel here at VidCon. Unfortunately, it's a busy day for me. We will keep you updated in the app if anything else happens, and if something else goes on with the jury, I will come back and chat with you about it later on today. When later on today, I don't know. I have a meeting with the entire memberships team of YouTube. So we are going to be talking all about you amazing members and how to make memberships even more amazing. And of course, I'm moderating a panel. It is a busy week of meetings, but I am here for you and I absolutely adore you. So let me get to questions real quick. After day 2 of deliberations, I started to be concerned about a hung jury. Yesterday, people were like, what do you think this jury's going to do? Like, in real life, people were like, shoulder tap, what do you think this jury's going to do? And I was like, with this amount of time and with the question that they asked for the police report, I think they're probably going to be unable to come to a decision on at least some of the counts. And that is where we are. I also have to go steam and warm up my voice so I can like actually talk. But let's answer some questions. Also, my internet is absolutely fighting with me, so I am sorry. It was better days before, but today it is just, it's VidCon. It's VidCon. So let's see. Could the cop on the jury be I don't know if there is a cop on the jury. I think that'd be an odd thing. I can't recall said, could they have a hung jury on one of the lesser includeds? They could. If so, and the Commonwealth retries, can Karen appeal the verdict slips? That's a lot of hypotheticals, but the issue with the verdict slips has been resolved. And if they have hung on one of the lesser includeds, they would have had to hang on the whole charge, because you don't get to the lesser includeds unless you're like, if you're not guilty on the main charge and then not guilty, then hung on one of the lesser includeds, they could only retry Karen on one of the lesser includeds. And I don't know if they would, but you couldn't get there until you get to not guilty. But they did not say very clearly, they did not say, hey, we have a verdict to some counts and not to others. They said, we cannot reach a decision. Melanie said, why not read the 2A Rodriguez instructions? The judge is going to do it later. She's going to send them out again. If they send another note, she's going to read the stronger instructions saying, go back and try to reach. Sometimes it's an Allen charge. Sometimes it's, it depends on the case law in the state of what it's called, but she will read a stronger jury instruction to them and send them back to do it again. So this is 1, 2, we'll get to 3, and that's, 3 notes about not being able to reach a decision. That's probably when the court will declare the mistrial and the hung jury. Flutterby ASMR said, I think there is 1 juror anti-Karen pro cops. It might be 1, it might be more. You never know. Cullen Girls says everyone is in a panic, like the emotions in Inside Out because Emily wasn't here. I've got you guys. No, don't worry. I'm not going to leave you hanging. I might be a little slow today, but I'm not going to leave you hanging. And I will make sure that we keep you all in the loop. Can the jury refuse to keep deliberating at some point? Yes. They can say in their note, no further deliberations would help. They absolutely can. And they will learn. If the judge sends them back again, they will send out another one saying, we are unable to reach a decision. No further deliberations will help. No other information will help. They will let the judge know that. If hung, chances of retrial, it depends on the split. I don't think this case is good to retry. It also, I didn't think they should have tried it in the first place, but it also depends on what happens in the federal investigation. Like there's a lot of and with this case. Thank you for the 10 memberships. What happens when the jury hangs? The court declares a mistrial and they are able to retry the defendant, but the charges don't go away. So it's not like the case is dismissed and there's no pending charges. The case just kind of starts over with okay, when are we setting the next trial date? So it just kind of resets into trial status. When are we setting the next trial date? That's what happens. And they'll normally set a status conference. The charges are not dismissed. And they set a status conference and set a trial date and decide if they're going to go again. So KLV said, thanks for being my virtual coworkers for 4 months. Hey, we're here and we're rolling into another trial at the beginning of July. So don't worry. Frankie's mom said, you're in SoCal. I wish I knew. I'm in Burbank. We can't do a meetup in connection with VidCon because I'm not doing a formal meetup at VidCon. And my schedule while I'm here is packed. So we are packed, but we will do a SoCal event at some point. Lauren said, can you explain the Rodriguez instruction and the Allen charge? I'm not going to go read it, but essentially telling the jury to go back and deliberate and encouraging them to reach a verdict. The thing is, encouraging them to reach a verdict is hard. So we'll see what the judge does. I don't know if the judge is inclined to do that or not inclined to do that, but the court can say, go try some more. And if the jury's like, that's not going to help, the judge might ask, would further deliberations help? And if all the jurors sit there like this, then the court's going to call it hung. You can tell. I had a jury hang and they walked in and like 11 of the jurors were like this. And one of the jurors was like, what? And the court was like, will further deliberation help? And all the jurors were just like, And it was 1. It was 1. And the rest of the jurors were incredibly frustrated. And they were like, there's nothing. There's no reason. There's no talking. There's no nothing. So that happens. It can be 1, it can be 2, it can be 3. But again, if you feel strongly that she hit John O'Keefe with her car, what are you going to do? Like, are you going to just be like, oh no, it's fine? And if you feel strongly that she didn't hit John O'Keefe with her car, what are you going to do? Oh no, it's fine. Like, this is a case where it's hard to move the needle because it's so impactful. It's a murder case. It's very, very impactful to everyone. So it's really hard to move someone who is like, I'm not changing my mind. Jenny says, do you think the judge Bev picking the 4-person before the alternates is sus? No, especially considering the alternates appeared pro Karen. I don't know how the alternates appeared pro Karen. The alternates were all picked by random. I try not to read things into that. The judge might always pick seat 1 as the 4-person. Some judges do literally always just seat 1 as the 4-person. Is it weird to do it before or after the alternates? I don't know what this court normally does. It's only weird if that's not what this judge always does. So if that's what this judge always does, it's just different than what other judges do. But the alternates were picked by like bingo roller. So the judge didn't like look at two people and be like, you gone, you gone. It was just random drawing of their seat numbers. EDB, I'm panicking. Please calm us down. That is why I went live, because I could see when I watched what was going on in court that there was going to be stress over this. Look, juries hang. Juries hang. It happens. There is time people cannot reach a decision. Lizzie, will we find out how many were split? At some point we will. It depends on how the judge polls it, but the judge needs to poll it. And the prosecution needs that info. Thoughts on why the judge didn't ask the split? Because she was immediately going to send them back in to deliberate more. The judge is only going to ask the split when the mistrial is declared. So, editor said, oh, I ended up with ice in my mouth. The DA and Bev won't make hard calls. The jury can't do it for them. It is too early to declare a split. The judge is going to give them at least till end of day and probably give them the weekend and say, go home and think about it over the weekend. And that's not unreasonable, given that this was a 30-day trial with 74, 75 witnesses. It's not unreasonable for the judge to say, take the weekend and think about it. And I'm on a plane on Monday. So do I think that's exactly what's going to happen? Yeah. Alex says, if they don't retry it, do the charges get dropped? They have to formally dismiss the charges at some point if they decide not to retry it, and they have to let the judge know they're not retrying it, and then the charges will get dismissed. Amber said, if it's hung, will we know who's on whose side, or at least the split? We'll know the split. Not all judges ask if that split is for guilt or not guilt. They should, though, because that's the only way the prosecution can really make a choice about going forward, and that's the way the defense knows whether or not they were convincing. I thought the witnesses for the defense, especially the biomechanical engineers, were very persuasive. So not all the jurors agreed. If they agreed, they would have been back in a really quick verdict, because you look at the biomechanical engineering and it's like, okay, well, I don't know how to get around that for me. But other jurors are going to be like, obviously they've got a problem with it, because otherwise we wouldn't still be here. KN Wags, good to see you. Poll percentages, majority not guilty, maybe a holdout. It's possible. But we just don't know. We just don't know. Amy's positive pathways, do they have to remember testimony by memory? Yes. Or is there transcripts or testimony? It's 8 weeks and like 70 witnesses. They can ask for readback of testimony, and it literally, they all come back into court and they read the transcript. So they can ask for readback. They've only asked for one police report. They've not asked for anything else. And that was a police report regarding the initial search for taillight pieces. That was it. And they're not allowed to have that because it's not in evidence. Gabrielle said, if the jury comes back today with the same result, will the judge still say it wasn't enough time? Probably. I think the judge will send them to think about it over the weekend. Bulldog Mom said, God bless you, Emily, we need you. I've got you guys. If it's a hung jury, can the jury talk to the media afterwards? Yes, they can, if they choose to. Aaron said, I agree with the questioning. Who let the cop on the jury? I don't know if there is a cop on the jury. So I don't know that for sure. Dorothy said, I needed you. I'm here. Home sweet home, please don't send us back to CRTV. I won't, but I do have a panel today. So if something else happens, it will not be till later, till I can go live. How much longer would be fair to make them go? Give them the weekend until the end of the day, Monday. They could do that a little bit longer, but I don't know if they will. So I'm a 4-time juror. We know when we're done. Respect. Yeah, they absolutely do. The judge still might give them the weekend. JH said defense looks defeated. They don't want a hung jury is my guess. They would rather have a hung jury than a guilty, though. Do you think they will retry her? I want to see what the split is. I didn't think they should try this in the first place. I think there's too many questions, but obviously some people don't think there's as many questions, because if they all agreed that there were too many questions here, we wouldn't have a jury that can't reach a conclusion. So, Lally knows his jurisdiction better than I do. I can only go off of what I've seen of the evidence that's public. And what I've seen of the evidence that's public, I wouldn't have taken this to trial. Call Me Al said, what is happening? The jury can't reach a decision. Dorothy says, does defense think a hung jury is going for them? It's better than a conviction. I think they rather have a hung jury than a conviction on a lesser included charge, because what the defense gets if this is retried is now they have statements to law enforcement for lots of the witnesses, statements at a state grand jury, statements at a federal grand jury, and then statements at a trial. So when these witnesses come up again, some of them have 4 or 5 recorded statements, and that gets better and better for the defense. Palmetto Phoenix Society, EDB, we are going to need you to plan life better to accommodate trials. Sometimes I just can't. You are the best, and I hate feeling like I'm cheating on you watching other people. Look, I'm speaking at VidCon. There is only so much I can do. This jury could have been back on Tuesday, and it would have been fine, but this trial also was initially supposed to be 5 weeks, not 9. So to have any life, I can only do so much. I did cancel vacations to cover trial in the past. This cannot be canceled. Donnie B said 99% of public says not guilty, and this jury can't see it. I mean, it only takes one person. Do they not believe the defense's last 2 witnesses? Maybe not. Maybe not. Brooklyn said, is the defense okay with a hung jury? I think they're better with a hung jury than they are with a guilty verdict. Thoughts on why the judge didn't ask the jury the split? Because she knew she was going to send them back, and she's not going to ask them the split until she sends them back. Some judges ask every time, and you can see the split moving, which I think is very helpful. But no, she did not ask them the split. Not to be conspiratorial, but doesn't this feel like someone digging in their heels? That happens on juries all the time. Very odd to me that they're giving up already. Because of the type of case, it's not strange to me that somebody would dig in their heels. This is the type of case where if you believe strongly one way or the other, no one's going to change your mind. And we see that on social media, right? No one's going to change their mind. So if there is spam in the chat, the moderators will yeet it, Amanda, because we don't do that here. So thank you, but they will get it. Do they still poll the jury if it's hung? They will at the end, or they should at the end. They've gone home early as they've indicated they wanted to the past few days. That speaks to how exhausted they are. I think so. And I think that's why the judge is going to give them the weekend to take a breath. J. Michael, good to see you. How do they handle splitting the charges, not guilty on the superior charges, but hung to the lower charges? Is this not a constitutional issue? They could NG on the superior charges and hang on the lesser includeds and just be retried on the lesser includeds. That's possible. I'm not sure what the issue would be created. Those are lesser includeds by law, and that's possible. And the jury form issue has been resolved, and those are with the edits that were made, those are the standard jury instructions in the state. Or the jury slips, as they call them. Bev has to do the Allen charge next. Well, no, she could send them home for the weekend and then do it on Monday, which she probably will. A new trial would probably be after the FBI investigation's done. Maybe. It should be. Too many jurors are listening to fuckery over facts. You never know how somebody perceives something until they actually tell you. So some jurors might be really put off by the way the defense did this case. If there are jurors that are like, look, this conspiracy, everyone else did it thing, I'm not buying it. I don't like it. So it could cause people to dig in their heels and be like, there was taillight here and she said this there. Just because I don't see it that way, it doesn't mean I don't understand how somebody could see it that way. I think the last 2 witnesses were persuasive. If I was debating with a juror, I'd be like, but this person wasn't hit by a car though. So they could be fighting over those lesser included charges, where the lesser included charges are chain of events. Did she cause the chain of events that led to John O'Keefe's death? And then there's more of a conversation about dropping him off and what if he fell and the rest of it. So they could be stuck there. And the lawyers did not explain those instructions at all. The lawyers did not tell the jury how to resolve those questions. Didn't tell them at all. So don't make more out of it than what we've seen. The jury is working and they are, at this point, not able to reach a conclusion. Cheryl said something stinks. Everything in my gut was telling me that something is up with this jury. It's the amount of time it's been taking. I think either someone in the jury is linked to the Alberts or got spooked. I'm I'm not going to read that into it, Cheryl. I can see, especially with those lesser includeds, people having reasonable differences. Jonathan said it should be considered unconstitutional to tell a jury that they have to make a decision. The laws are coming from case law, and they can encourage them to make a decision. If they come back and say they can't agree, they shouldn't be forced to. And they generally don't change their mind. Have a great time. Thank you so much. I will. I'm going to go make sure that we do all the voice things so I sound a little bit better. Anna said to me, this just confirms the majority of people don't understand or respect the meaning of reasonable doubt. The prosecution on easy mode. I mean, somebody doesn't agree, otherwise they'd have a decision. Why isn't the difference between innocent and not guilty explained? I don't know if they need to, because the focus is not on not guilty in this case. The focus in all criminal cases is guilty beyond a reasonable doubt and whether or not that can be proved. So they don't really spend the time focusing on what not guilty means, because the jury's not being asked to find factual innocence. Let's see. Susan, thank you very much for the super chat. Sam, I am aware that Netflix used some of my content in their documentary. Kristen said, can the prosecution drop the charges after a hung jury? They can. Yeah, they can. They can choose not to retry the case. Jay Fernandez said, my level of anxiety and emotional investment in the outcome of this verdict feels unreal. This could be any of us. My brain can't comprehend how someone can discount science. This seems so obvious, which I understand, which is why there's so much stress around these jury questions, right? And a lot of feelings of stress. Do you think if hung, the Commonwealth would try for an Alford plea? No, I don't think so. An Alford plea, by the way, I need to look at what the rule is in Massachusetts, that allowing Karen to say she's pleading or she's taking responsibility but not admitting guilt. And I don't think she would do that after this. Do you? Like, do you think after this trial she would? I don't know. Did I hit him? Drop the did has a new meaning. And that's what the prosecution argued. Melanie said 12:05 CST and just got my notification. Thank you, Melanie. That is helpful to know. Amazing Meta said putting everyone and their mother on the witness stand is how you baffle the jury with BS and cause a hung jury. Maybe. The jury might have been like, oh, well, there were so many witnesses, it's overwhelming. They're told in the instruction not to count the number of witnesses on a side. Susan said, does this jury in Massachusetts get all the evidence and transcript and back? Not the transcript, but they get all the evidence if they want it. I don't know if it was automatically taken back to them or if they had to ask for it piece by piece, but they get it. Will Lally have to ask the feds to retry it? No. Lally can do whatever he and his office decide. Do they poll the jury for a split if hung at the end? Most jurisdictions do. I don't know what this judge does. Crafty Crafty said, you were found not guilty. That's not innocent. And you need to apply for innocence. This baffles me. It's meant to be innocent until proven guilty. Same with the hung. Yeah, not guilty does not mean innocent. Not guilty means the Commonwealth or the state did not prove it beyond a reasonable doubt. Factual innocence and finding of factual innocence are rare, and they are a different thing. But it doesn't mean that you are factually innocent. It means you are, in fact, not guilty because the state didn't prove it. So there is a differencing in language between innocent till proven guilty and not guilty, because they are different things. So hopefully that helps. For all of you saying you just got the notification, that is later than we anticipated, and I am sorry for that. I have got to go finish getting ready for my panel because I have to go speak on a panel. I will keep you guys in the loop if we see anything else. This jury is at lunch now. They will be at lunch for another hour. After that, we will see what they say. The jury comes back to be dismissed from the court at 3:30 p.m. Eastern. So I will be over in the Anaheim Convention Center. We will keep you updated in the app. If anything else happens, I will be going live later on in the day because I have a few meetings, but I've got you. And we will keep you updated in the Law Nerd app, and make sure you have your notifications on here as well. with all of that, do all the YouTube things. And I am going to, go do all my stuff. We're going to put the info for the panel in the app. We'll send that out. So you have the time and the name of the panel. If any of you are watching VidCon streaming, it's a main stage panel. So, or an amplify stage panel. So I think you should be able to see it, but I'm not sure about that. So we'll put it in the app so you guys have it. With all of that, Law Nerds, thank you for being here. Let's do a quick summary and then we're going to go one more time. The jury came back with a note this morning in the Karen Read trial on day 4 of jury deliberations saying that they have done an exhaustive review of the evidence and are unable to reach a decision. After talking to the lawyers, the judge brought the jury out into court and then said, look, have lunch, clear your head, take more time to deliberate. I think if the jury says the same thing at the end of the day, the judge is probably going to give them the weekend. It is a Friday. The judge is probably going to tell them to go home for the weekend and take a break and come back on Monday and try to resolve the case, which means we may have a final resolution on Monday. I don't know if the judge will do that today. I think she's going to want them to take the weekend to sleep on it, to talk about it, and we will see. Maybe the jury comes back on one of the lesser included. Maybe they don't. This is a difficult case where if you believe one way or the other, it's going to be hard to sway someone because of the weight and consequences of this case. The jury knows it's a murder case. And that is something that when the court says you can only convict if you find her guilty beyond a reasonable doubt and to a moral certainty, I can see there being jurors saying, I can't believe this to a moral certainty. And I can see jurors saying, I think she did this and I can't say otherwise. And that is where you end up with that hopelessly deadlocked jury that cannot come to a unanimous decision. And again, the longer a jury deliberates, the more likely it is that it's because they cannot reach a verdict. So in this case, if they do not reach a verdict, if they go back and deliberate and still do not reach a verdict, eventually the judge will give them a stronger instruction and send them back again. And then if they cannot reach a verdict on any of the charges, the court will declare it a mistrial. And then they will set a future hearing date and they will come back to court and decide if they are going to continue prosecuting the case, if they're going to retry it, if they're going to change the charges, if they're going to dismiss the charges. And then the prosecution has a lot of options on how to proceed forward. But what that means is we could do this trial again. If that's the result, they could bring in a lesser charge and allow Karen Read to resolve the case for a lesser charge. I don't know if she'd be inclined to do that. I don't know if the prosecution would be inclined to do that. They could dismiss the case and not retry it. There's a lot of options here, but I would be surprised at this point if this jury is able to reset and come to a decision. I think what we will probably end up with here is a mistrial. So everybody take a deep breath. It's frustrating, but we will see what happens. I don't think we will have a final decision today. We may not. But keep an eye on the feeds. Keep an eye on the Law Nerd app. I'm going to go do my panel at VidCon. I will see you soon. The timing is just of course it is. Just of course it is the timing today. But if something else happens, I will be back with you and I will keep you posted again in our app. Thank you for being here. Thank you for being a Law Nerd. You guys are the best. And isn't it kind of fitting? Isn't it kind of fitting? What happened to John O'Keefe? And even the jury's like, yeah, we don't know. We don't know. We don't know. Very, very, very frustrating. But the jury gets to make this decision and they have to be able to rest well with the decision that they make. And if it was you and you felt a moral certainty one way or the other, is there anything anyone could do to change it? And that's where we're at in this case. Law Nerds, I will see you soon. Stay posted in the Law Nerd app. Bye.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media. And don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.